seconds to go. Start. The resultant effect is that though there is a strong suspicion of criminal breach of trust, cheating, and or fabrication of the bank records against the appellant, but such suspicion falls short of a conclusive proof to hold him guilty of the criminal charges. The best evidence having been withheld by the prosecution, the benefit of doubt must be extended to the appellant, for no conviction can be sustained on the basis of conjectures and surmises. Non-production of the records of the bank also adversely comments on the fairness and independence of the investigation conducted in the instant case. To sum up the above stated discussion, the following incontrovertible factors have emerged in the present appeal. First, no financial loss was caused to the bank. Second, the record before us does not indicate that any pecuniary loss was caused to B. Satyajit Reddy or to any other customer of the bank. Third, the material before us does not disclose any conspiracy between the accused persons. In the absence of any reliable evidence that could unfold a prior meeting of minds, the High Court erred in holding that appellant and other accused orchestrated the transactions in question to extend an undue benefit to accused number 3. Fourth, the appellant committed gross misconduct by misusing his position as the branch manager. Notwithstanding the final outcome, the appellant's abuse of powers clearly put the bank at the risk of financial loss. Fifth, despite dereliction of his duties, none of the acts proved against the appellant constitute criminal misconduct or fall under the ambit of sections 409, 420 and 477A IPC. We face no difficulty in holding that the prosecution has failed to prove the charges under sections 409, 420 and 477A IPC against the appellant beyond reasonable doubt. As a necessary corollary thereto, his conviction under section 13(2) read with section 13(1)(d) of the PC Act can also not be sustained. However, the benefit of doubt being extended to him on account of a thin margin between strong suspicion and conclusive proof shall not entitle him to initiate a second round of lists to seek his reinstatement to or to claim other service benefits from the bank. We have already held that the appellant is deemed to be guilty of gross departmental misconduct for which the punishment of dismissal from service has been adequately awarded. It requires no repetition that standard of proof to establish a misconduct in a domestic inquiry, that is, even preponderance of evidence, is drastically different to those of proving a criminal charge beyond any reasonable doubt. The appeal is accordingly disposed of in the above terms. Bail bonds, if any, furnished by the appellant stand discharged. Stop.